Gilbert? Mr. Fallon?
Good morning, Your Honors. Richard J. Fallon for the defendant Preston Gilbert, convicted of first-degree murder of his common-law wife, Lana Gilbert. Very briefly, I first want to address the jurisdictional issue brought up in the memorandum of law allowing leave to appeal, whether this is appropriate gatekeeper petition. And I would say if simply asking a question will give you the answer, and the question is whether you have authority here to, whether you would have authority to reinstate the first-degree murder conviction. No one's asking you to do that. In fact, the Commonwealth accepted the second-degree reduction. But I would suggest that indeed you do have authority, that the motion was filed when Mr. Gilbert was convicted of first-degree murder, and I suggest that that's the dividing line. For example, in the Latimer cases and the other cases, if there's a situation where you've finally reduced it to second degree, or there's been a final reduction to second degree, then if there was, for example, a subsequent motion based on newly discovered evidence, then it wouldn't be gatekeeper. But I would suggest when the motion is made, when there's a first degree, it is gatekeeper.
Mr. Fallon, let me see if I understand you. Are you saying that if we conclude that the trial judge erred in his legal conclusion that there's a substantial likelihood, risk, whichever one is appropriate here, of a miscarriage of justice, that we can reinstate the first-degree murder? I'm
not saying you should. No, not at all. In fact, I've asked the second degree.
My question was could.
But I'm saying, sure, I suspect under 33E, I think you do have
well, surely under
powers.
Surely under Rule 25, we have overruled reductions from first to second degree and reinstated the first degree murder conviction.
Sure, and that's all I'm saying, and that's why this is a gatekeeper. Moving on very briefly to the Rule 25 issue. And in this case, what the judge did, we must remember, is judge conditionally allowed the motion for new trial and then said to the Commonwealth, you can either accept the reduction to second degree or we'll have a new trial. And so you could almost argue that the Commonwealth made a motion to reduce in a way. I could see that. But my suggestion and my argument is basically based on a claim that it has to come, that the motion under 25C to reduce a verdict rather than motion for new trial has to come from the defendant. And I would put all the evidence.
And there's a serious reason why that's so, is there not, which you don't mention in your brief, and that is double jeopardy. He was tried by a jury and found guilty of first-degree murder. He was not tried by a jury and found guilty of second-degree murder.
Yes,
he made no motion under Rule 25 within the 5 days after the verdict came in to reduce it.
You're right.
So here you've got a result imposed by a judge over the defendant's objection, because you're arguing here it should be manslaughter or a new trial altogether. And seems to me that creates a jeopardy problem.
Exactly, Your Honor. And
but that's not mentioned in your brief.
Well, that's why Rule 25C only says Commonwealth can appeal. And if I mentioned it, if I didn't mention it and missed it, it's ineffective assistance of counsel.
So I thought, maybe I'm confused, but I thought you did mention it.
Well,
you talk a little bit about the defendant should make the motion and all that kind of stuff, but you don't stitch it all together. I based it on, I'm not sure I mentioned double jeopardy, Your Honor. I did mention Rule 25C.
Well, maybe Judge Gantz's order says it. But he said that.
Not really. What is the analog federal rules do here? Have you looked into them?
I'm sorry, I don't recall. I believe. I'm sorry, right now I can't say.
Don't they, in essence, collapse Rule 30 and Rule 25 and say you have to bring it within 100 days or something? You can't. I mean, the problem here, as I see it, Mr. Fallon, is that there's a 12-year lapse of time that seriously impacts the Commonwealth's rights here. Seriously impacts. And as I understand, and I may be very vague about this, the federal rules can't have a collateral attack later, correct? You can't. You couldn't. Under the federal rules, you couldn't bring this up 12 years later, correct?
Under the motion for new trial, I don't know, Your Honor. I'm only here under the Massachusetts motion for new trial, which you can.
Isn't this going to create chaos? Aren't we going to have every person with a first-degree murder conviction down in Walpole, looking through the record again to see if they can spot some kind of error in the instructions, and then moving under Rule 30 and say, give me a 25B reduction. And then I'm eligible for parole because I've been down here for so long and all that kind of stuff. Could be error in the felony murder instructions. Could be error in what type of thing we got here today.
Well, this is a double.
Could be all kinds of things.
I don't think so, Your Honor, because I think this is a very unusual double error situation. In other words, the first error was the premeditation. The question when the jury said, is premeditation to inflict grievous injury, murder 1 or murder 2? And the judge, instead of saying, well, you need intent to kill for premeditation, first-degree murder, gave all 3. So that's the basis on which the judge went to second-degree murder. Now, that has a surface justice to it by itself, because you say, well, yeah, the jury will confuse. But the problem is the second serious error. And that's what I want to address here now. And that's the substantive reason why, indeed, you should grant a new trial, because it's manslaughter. And the second substantive error, this double error, is precisely the third-pronged malice error.
That may be the case in this case.
Yes.
Yes. But what I'm slugging with is your claim, which as Justice Lane's question elucidates, seems not to be preposterous, which is you go through an appellate review, in this case a murder 1, so you've had 33E, that I think is largely irrelevant. Then at some point the defendant says, look, something was missed here, right?
Right.
For whatever reason, and brings a motion for a new trial.
Right. Yes.
And the trial judge concludes, I believe that there's a substantial risk of a miscarriage of justice, and so I'm going to order a new trial. Right? That's what you were arguing for.
Right.
Correct? And then the Commonwealth appeals, and then the appeals court, or this court, whichever appellate court has it, looks to see whether the judge is correct.
Yes, sir.
And does the Freeman analysis. I think what Justice Lane is suggesting is that if the trial judge can do what this judge did here, then, when you don't have your unique circumstances where you say there's a possibility of a manslaughter, that's why I want to go to trial again.
Right, exactly.
For whatever reasons, it is as if you were a sort of lower threshold, because maybe you get a new trial, but maybe just because you lose all the witnesses, I can get a reduction in sentence.
Right, yes, sir. Well, I mean, if
you're arguing, I can't have it in this case, because I've got available to me a manslaughter option.
Right, exactly.
This court concludes
you're saying broader in other
these
cases.
jury instructions permitted that option. I don't know how valid that, but at least that's your theory. In other words, you're not making the procedural argument, you're making the in this case argument.
Right, the Rule 25.
And I'm focused on the procedural argument.
Well, the procedural argument, I'd say that amend Rule 25 on that basis.
To say what? If
it's not a double jeopardy. To say what Rule 25A says. On his own motion, in other words, Rule 25A, as I recall, says on his own motion or motion of the defendant. Unless there's a double jeopardy issue, as Justice Green.
Well, I mean, this is an unusual rule because it's in the context of a statute.
Right.
Right?
Yes, Your Honor.
And in essence, the legislature has given to trial judges the power that it earlier had given to this court.
Except I don't think it gave the broad 33 to reduce a verdict. On the 33, and in fact I forget the name of the case. You don't need, I think it might be Lennon. You don't need a motion. You can do basically what Justice impels. You don't need a motion.
No, you don't need a motion,
But I want to address what I think is a substantive issue, and I really want to get to it here, which is the third-pronged malice error, which the judge said, well, that's non-prejudicial because of the severity of the injuries. And the judge did not sufficiently address it, viewing him at the light most favorable to the defendant. And in fact, the Commonwealth doesn't do that at all. But here's the issue, Your Honor, because if we look at the evidence the light most favorable to the evidence, what did the jury verdict say? And it said that Mr. Gilbert was at least substantially, at least partly involved in the death through blunt neck trauma by hand fist, or cane. And I want to emphasize those three, because that's what the bill of particulars said, hand, fist, or cane. That's what the judge's instruction on transcript 1291. I can read it. The judge told the jury, and I quote, "The defendant has been charged with the crime of murder, and the Commonwealth has said that Lana Gilbert died as a result of her carotid arteries being crushed and torn. A hand, fist, or cane all could have inflicted the damage." And then finally, that's what the Commonwealth's own experts said. Dr. Kessler said a jab or a punch or a squeeze. Now, here's the key point. Even though the Commonwealth argues it was strangled, if I agree 100% there was sufficient evidence to find, but this isn't a sufficiency of evidence argument. Because it's erroneous jury instruction, it's the exact opposite. You have to do it.
This is the substantial harm thing you're talking about?
Yes, well, I want to get to why I think the key, why it is a substantial risk. But this is why it's prejudicial.
Why this erroneous instruction on third-prong malice
is prejudicial.
It's prejudicial.
Yes.
But before you get to that, were there cases around back in 1996 when this conviction was affirmed that even focused on that language?
Oh, that's a long story, Your Honor, but
Johnson didn't come out until a few years later.
Viscarando, I think, is really when the first real...
Well, that's a long story.
That was like 98.
Well, it is a long story because I think what you're doing is, to some extent, you haven't talked about this very much, you're retroactively applying case law, are you not?
Well, how so? Azar, I think, covers the motion for new trial.
Yeah, but when was Azar decided?
Oh, 2002?
Well, what I'm saying is 1996, when this conviction was affirmed, there weren't any cases out there that said this is error. So nobody be looking for it to begin with.
Well, the problem is that it goes back to 1980 in the Huard case. The Huard case, I hate to say it, was wrongly decided by this court. I'm not sure anybody here was there. And that's when, in Viscarando and Azar, you finally said, well, gee, we made a mistake back then. So,
okay, so
I agree.
We've got a little retroactive problem here, do we not? Or do we
well, no, we don't, Your Honor, because you said in Azar, you said yes, on a motion for new trial here, right.
Well, I know
it's an error.
Azar case, exactly. But the first case, I think, was Viscarando.
Right, the first one to really articulate it, yes.
And said, you know, it's wrong to use this kind of language.
Yeah,
that was 2 years after this
well, actually,
conviction.
Sears said it was wrong, and then you had a couple that went back the other way. But Viscarando was the first one that really addressed it.
So that's 2 years after this thing was affirmed.
But the law was wrong back in 1980. I mean, that's what you said. It's not. In other words, the problem is you had two parallel. What you had from 1980 on is two parallel.
I'm just looking for an answer on, you know.
Put it this way. To tell you what, I don't know what's worrying Justice Laney. What's worrying me is we have a very experienced, highly regarded Superior Court judge. Right? So this is not one of those cases.
You're right. No question.
So I can practically guarantee that between 1990 and whenever Viscarando was, you know, very highly regarded judges in the Superior Court were all giving these kinds of instructions. Now, we've got a very long period of time.
Right.
Because we've now got 12, 13, 14, 15 years, and as the trial judge said, you know, that puts the Commonwealth at substantial risk of being able to retry this case.
Yes, sir. You want to...
I guess what I'm saying to you in so many words is if all these inmates that are serving life imprisonment, and there's a lot of them, that prior to Viscarando, whose convictions were affirmed with this kind of language in the instructions, because it was pretty much standard in those days, are they all now going to jump up and come back here and say, oh, look?
Good question, Your Honor. And that's a key point here. Two key points of my time here. One is, you've pointed out, you have to show it's prejudicial. And if it's a gun, knife, or a prolonged assault, it's not prejudicial, okay? And that's the key point. In here, if the testimony had only been by Dr. Kessler, it had been a cane or strangling, what I call manual strangling, I'd have a really hard uphill argument. But that's the punch. The inclusion of the punch in the fist, the Williams case is a class, the inclusion of that makes the key difference. And that's the whole point, Your Honor. If it was a cane, you could say dangerous weapon. If it was strangling by squeezing, your Mendes case, that's strangling, that's surely intent to inflict grievous injury. But here we have the other alternative that the Commonwealth hasn't, tries to ignore, but we have it, a punch or a fist. And I want to emphasize, I know I'm running out of time, but I think the key point for substantial risk, because you have to find a substantial risk, not just the fear of
find prejudice.
Yeah, here's the two key points, Your Honor. One is Mr. Gilbert was a chronic alcoholic, and that testimony came in. In fact, there was evidence that at trial he admitted to having a second beer and then buying 8 beers. And so that makes it much more likely that the jury might not have found intent to inflict grievous injury. But the key point here, Your Honor, I would say the key point why it is a substantial risk, why it should reverse, is the prosecutor's argument at trial, where, and I quote, in closing, I quote, and it doesn't take any more pressure, ladies and gentlemen, than popping one of those stalkers off one of those beers that he drank that week to put the thumb, finger, or cane on the throat of Lana Gilbert to cause her death. Well, two things jump out at me. First, he ignored the punch or the fist, which is exactly what makes this prejudicial. But the second thing, that's a classic third-pronged malice error. The Commonwealth is here arguing that it's had to be strangling, and so the third-pronged malice error is non-prejudicial. Quite the opposite. The evidence is that it's punch. There was conflicting medical evidence at trial, which is very important. But all we know is they could have found, what we know, if I had to sum up in 25 words or less, what we know from the jury's verdict is the jury could have found that a punch was the fatal blow. Did not have to find, in other words, you remember the emergency room doctor said all these other bruises were old, whereas Dr. Kessler said they were new. The only thing we know that they found that Dr. Kessler was that a hand, fist, or cane. And the jury could have found a punch, and that's not prejudicial. And that's why the real basic comes down to the injustice is the jury could have found what constitutes manslaughter and came to this first-degree murder. And that's why it's a substantial risk of miscarriage of justice. And if you don't have any further questions, I'll sit down.
Thank you, Mr. Fallon. Mr. D'Angelo.
Good morning, Your Honors. May it please the Court, good morning. My name is Peter D'Angelo, and I'm an Assistant District Attorney in Middlesex County. I represent the Commonwealth in this particular appeal. As to the first issue, the jurisdictional issue, when I was writing my opposition to the defendant's gatekeeper petition, I had on my desk another case in which a judge on the 25B2 took a murder one case and reduced it all the way down to manslaughter. And I thought that because it was met the definition of a capital case, that the case should have come here to the SJC. Rather, the case was docketed in the appeals court. So when this case occurred on the 25B2, where Justice Gantz reduced the verdicts from murder 1 to murder 2, I felt that gatekeeper wasn't appropriate because if 25B2 and 33E are similar, and the cases like Cahill and Woodward and cases like that do cite that they are similar in purpose, similar in scope, not exact.
How can you use 25B2 on a Rule 30 motion? First of all, 25B2 says it applies only if the motion is filed within 5 days of the verdict. Here we're talking, what, 10 years later, I guess, something like that. That's point number one. Second, there's no case that I can find, and the ones the judge cites don't support what he did, that says on a Rule 30 motion you can do 25B2. So how can you do 25B2?
I think the second sentence doesn't contain a time limitation.
What does that say?
The second sentence, I think the case called Foreign, which I cite in my brief, I also want to say Galt, and I cited in a footnote, and the court has, on occasion, said, maybe this rule should be amended, maybe we should think of adding a time limitation to the second sentence of Rule 25B2. Yes, sir.
Except 25B2, as I understand it, was essentially mirrors the statutory amendment, correct? The 1979 statutory amendment that gives to superior courts what we colloquially refer to as 33E review in the Supreme Court, right?
I believe so, yes.
And this is if a motion for directed verdict of not guilty is denied and the case is submitted to the jury and a verdict of guilty is returned, the judge may, on a renewed motion for a directed verdict of not guilty, set aside the verdict and order a new trial or order the entry of a finding of guilt of any offense, including the offense charged in the indictment. I mean, there's a limitation on when you can file a renewed motion for directed verdict of not guilty. And if it is the case that, I mean, this is defendant-oriented. This is defendant-oriented, right? The defendant didn't ask for that. We just got Rule 30 here. That's a motion for a new trial. That's a whole different animal.
There's nothing in Rule, I'm looking at Rule 25B, 1 and 2. There's absolutely nothing in there that permits something like this 10 years after the fact. If a motion is made at the close of all the evidence, that's part one, the judge may do this, that, and the other thing. This wasn't filed at the close of all the evidence. Then the second one is if the jury's discharged, they can renew it within 5 days. That wasn't done here either.
There are cases, though, I would cite there, in a footnote in my brief, I think it's footnote maybe 6 or 7. I cite Thoren. I'm trying to think of the case. It might have been Galden. There is no time limitation. I mean, indeed, the case.
No, there's no time limitation. Right. But the question is, if you've got a motion for a new trial, and this Commonwealth has not an unusual, but we have a fairly liberal motion for a new trial.
Correct.
That is, there's no time limitation. But everybody understands that you've got to both show error and show a substantial risk of a miscarriage of justice. And the stakes are pretty high at that point, because in essence, what we are doing is saying either you affirm the conviction or you get a new trial. I don't know any case where, I mean, it may be that some cases have taken a while.
There really, and this is a problem in terms of this case. There was one case the judge cited, and there's really one case that you could find for the proposition that on the Commonwealth's request, it's Commonwealth v. Lennon. In that case, the judge.
Lennon's an SJC case.
It is an SJC case. It is 33, exactly.
It's a 33 case.
Exactly.
Yeah, that's right.
There are no 25B2 cases.
It has no application.
Of course there are no 25B2 cases, because the whole point of 25B2
right,
is not
but the
this.
problem is a question of waiver. And this is what I also a question of fairness and waiver. In 1996, when the defendant stood before this court, had he raised this error, like we keep saying time and time again in these cases that he's required to do, had he raised this error under 33E, I think reading Lennon the way I read it, the Commonwealth could have got up and said, Your Honors, yeah, this instruction of first-degree murder was entirely wrong. Would you please reduce it to murder in the second degree?
How could he raise the error when the cases hadn't even been decided, saying that it was error?
Well, you know,
I mean, he could have if he was
he could have. I mean,
really
hadn't
smart.
read the instruction. I mean,
But nobody was even looking for
and
it
the jury,
in
well,
those
but the
days.
jury's question too. No, the error wasn't third prong. The error in this case was that all three prongs of malice were read to the jury in their first-degree deliberate premeditation charge.
Yes, and then what the judge does.
Right. That, I think, was developed at that time. It wasn't the third prong yet.
But then as I understand our jurisprudence, the judge says this was an error. Then you look to see whether or not, I mean, our case law develops all of the time, and we don't go back and retry every criminal case. Then you look to see whether or not this error has retroactive application, and it might. And it might. I don't think that's here at the moment, and it might. And then if it has, you look to see, if there's a substantial risk of a miscarriage of justice, and if there is. So one, if there's error under current case law. Two, is if it's retroactive. Three, is it a substantial risk of a miscarriage of justice. You get a new trial. That's our case law.
Right, Your Honor.
And it's very harmful to the interest of the people of the Commonwealth of Massachusetts, because it can be brought 12, 13, 14, 15, 16 years later when witnesses have moved and memories have faded and so on and so forth.
Exactly.
But we permit it, but the substantial risk is a very high threshold.
It is, Your Honor, and it's a question not answered. I mean, there are no cases, and it's certainly one of those issues in terms of trying to cite something to the court. It's difficult, but I would state that it becomes a question of this court in interpreting 25B2. Did Justice Gantz interpret it in a manner that it might be sustained or upheld? And I think it's a question of what tools we're going to give trial judges under 25B2 in a post-conviction posture. The problem with this case is you won't find a case 25B2 is used in a post-conviction posture like this after the defendant has received appellate review.
Mr. D'Angelo, could I just ask you this, and maybe a little unfair to you? Let's assume that the law is, as the Walton judge correctly articulated in the wake of Azon, Viscarendo and Azon, a whole group of other cases, Johnson and others, should this defendant, having raised it, having challenged these jury instructions in this case, get the benefit of that later case law?
That's the retroactive problem.
I would say no, but I don't think that's what the court would uphold. I think the court has said prior. I mean, as a prosecutor, I say.
No. What is our jurisprudence on that?
Our jurisprudence, I think, is that the defendant would get the benefit at the time he brings the motion. I think in Azar.
What case says that?
I think Azar. Not Azar. In terms of. I do know that is the law in terms of, it wasn't something that was raised in the briefs or briefs, but in terms of my understanding of the case law, he would get the benefit because he's bringing his motion for new trial later after the issue was sufficiently defined. I mean, Azar was I think Azar was Azar also noted as well the simple fact that it was prejudicial to the Commonwealth, it was unfair to the Commonwealth, but that's the way it is.
Was Azar brought years after the conviction?
Yeah, it was quite a long time.
Yes, it was.
Okay.
It was, Your Honor.
All right, maybe Azar does it for you. We'll have to take a look at Azar.
Yeah, I mean, that's the best case that I have in terms of that issue, but my understanding is in terms of appellate law that the defendant certainly would get the benefit.
Doesn't that get to the issue that this defendant is raising, which is that language, which I think is in Viscaranda originally, which is the ineluctably inferred evidence, and what this defendant is saying, you cannot ineluctably infer from the evidence here that you get to second-degree murder.
I think you can. I think Justice. I think the evidence before Justice Gant certainly would have allowed him to do that.
How do you deal with the punch?
I deal with the fact of the testimony. I cite to the court Commonwealth v. Russell. It was a third-pronged malice instruction in that case. A little bit different facts, but the court said in evaluating this, we have to look at evaluating the third-pronged error. We have to look at the way the defendant tried the case, and we have to look at the evidence. Juries ground their verdicts in evidence. In this case, there was two ends of the spectrum. The Commonwealth, its expert, blood neck trauma, similar to strangulation.
No, I understand that, but just deal specifically with the punch.
There is no punch. No one testified that there was a punch, that it was a single punch. My expert testified it was several blows with a cane, fist, or a hand to her neck, very close in time, and it was similar to what Dr. Kessler testified he had seen in other strangulation cases. His expert said it wasn't strangulation. She died of synergistic intoxication by mixing Tylenol and aspirin.
What about I thought there was a punch to the abdomen that caused injury.
Correct, but I want to add this. There's an injury instruction, and I note this in my brief as well. The defendant was very concerned. He said, look, I don't want them mixing and matching. The Commonwealth has to prove that this was blunt neck trauma, that this is what caused the victim's death. Is, he got an instruction that we prove the victim died of blunt neck trauma.
What you're saying
is... Blunt neck trauma.
Blunt neck
trauma. So it's, so that even if it's a punch...
Right, but...
The punch was to the stomach.
There was a punch, no, there were a number of punches to the stomach, but...
So what you're saying is the way in which the case was tried...
Right.
It was either, the option for the jury, in so many words, was either to find very severe trauma to this woman's neck from strangulation, being hit with a cane or whatever, or to find that she, in essence, killed herself by taking these drugs.
Exactly.
So the question of third-pronged malice may even drop out of the case.
It does. And that's what Justice Gantz found and said, this case can be saved. He said, because it's clear.
But that's only if it can be saved.
I think it can be.
I mean, if you go on...
How do you deal with the...
It's patently unfair, unfairness, Your Honor.
I understand.
It's patently unfair to say that the defendant, he's supposed to raise this 96, well, the case law wasn't developed. I understand that. He got to raise it later. In my brief, I'm not complaining about that. But at the same time, too, the trial judge said, well, this case can be saved by a reduction in verdict. Let me do that. Let me save the case. And then to say that he can't do that.
You're not challenging the judge's ruling.
No, I'm not challenging the judge's ruling one iota. I think what this is probably the first time a prosecutor stood here and said 25B2 second sentence is a wonderful thing. I'm sure that doesn't happen a lot. But in this case, as a tool in a post-conviction posture, Justice Gantz said this case can be saved. It's patently unfair not to do that if I can do it. He looks at the evidence. He says I can do it. And again, I go back to my argument, which is quite simply that the defendant should have raised this in 1996. He did it. The law changed. He got the benefit of that law, and I'm not objecting to that. But I'm saying that the trial judge had before him a
Well, if
situation.
you go on
where-
my theory, he gets a new trial, period. The 25B1 or 2 doesn't enter into this at all.
That's why I said to you, you haven't challenged the judge's ruling that there was an erroneous instruction that gave rise to the substantial risk of a miscarriage of justice.
That's correct, Your Honor, because it's our opinion that he had the authority to enter
No.
this reduction. I mean, and again, exactly right. No,
We've
you're
got to
right.
write a decision.
We couldn't establish.
We've got to
I
write
could
a
not
decision
establish.
that's going to be looked at by every first-degree murder convict, of which there are many down in Walpole, and you know,
Well, I can say,
I could
Your
see
Honor,
all kinds of
Yeah.
trouble coming out of this.
I necessarily don't, for the reason that you don't see a lot of cases. I've actually had one or two cases where the defendant tried this, and, you know, it's been denied and it was never appealed after that. I will say also that it's rare. There aren't a lot of published cases in which a murder one case was taken down to murder two.
I'm not focusing on the murder taking down to murder two. I'm
Right.
focusing on the error and the substantial risk of a miscarriage of justice. And as I understand Judge Gantz, he said, this is what the Supreme Court has told me to do. He said that several times, and he's a careful judge, and he said, when I find this kind of error, this is what the Supreme Court has told me to do. Not on the reducing it to second, you know, but
Right, in terms of the first part, well, he did find it created a substantial risk of a miscarriage of justice. And I believe that, in fairness, I mean, the way that it's abuse of discretion if he ruled on it and allowed the Rule 30B motion.
What if he's wrong?
If the court, I don't believe he was, because the jury comes back with the question that said something to the great odds of, does deliberate premeditation of grievous bodily harm, is that murder one or murder two? Because it's like chewing on glass.
And the court doesn't answer the question as it should have.
Right.
Which is
No,
no.
it absolutely doesn't, and it becomes a problem. And I mean, really, I tried to argue with the judge. I argued in my motion for new trial in opposition. I argued the standard. I said it can't be a substantial risk. You know, the deliberate premeditation charge was very clear and emphatic. I pointed to the court in Commonwealth v. Johnson. This court had suggested in similar circumstances, and I think that's footnote 8 in Commonwealth v. Johnson. I cited it in my brief.
Yeah.
That a reduction where all three prongs of malice are read into the record on the deliberate premeditation charge, that when that happens, when that situation occurs, a reduction to murder in the second degree may be appropriate. It said that neither the defendant or Commonwealth asked for such a reduction to cure that type of issue, assuming malice could be found. So I looked at that Johnson case and I said to myself, well, certainly if the defendant had raised this, and I go back to the same thing, but had he raised this when he was supposed to, that was an option to fix this error. That option should not be taken off the table because the defendant waits another 6 years to file the motion, to point out the error, and then say, oh, now you got to give me a new trial. Nothing else will do. Well, you know, it's been too long for us really to go back and retry this case.
No, I understand, and I think
and it's a problem. Well, I know, Your Honor, but
I think what the motion judge was trying to do, and you've been very frank with the court, saying, I think the motion judge is carefully following what he believed his obligation was. He went through, you know, the 3 reasons and determined for himself that there was a serious doubt whether the result of the trial might have been different had the error not been made. And then he was, you know, looking at the concerns that jurisprudence gives rise to, namely the inability of the Commonwealth, or the difficulty, I wouldn't say the inability, you know, the substantial difficulty of the Commonwealth to retry it.
I suppose you could observe that the trial judge might have been misled. There was a footnote in Azar that in which the court noted that the motion for a new trial from the defendant was framed in the alternative as a Rule 25b2 motion in Azar. We didn't rule on it as a 25b2, but the motion was filed that way.
I think
and the court noted that.
I think maybe, but I do know there was a case, Commonwealth v. Preston, and that was a case that was discussed a lot, and the judge relied on it. And it talks about the word motion. Because originally, and again, we're tied to what was argued below. The defendant originally below said, the second sentence of
Preston was a motion under Rule 30, and they said, if I'm remembering it right, and they said it could be treated as a Rule 25.
You know, that's absolutely correct, but the court did, in passing, address, it was the Commonwealth's contention, saying that, you know, there was no motion before the court. You couldn't enter a 25b2 motion for the defendant for new trial. The court said it didn't matter. It was, you know, 30b, 25b. But the court went on to note that the word on motion in the second sentence of 25b2 is there to prevent double jeopardy concerns. If the defendant file a motion, if you enter a a new trial or entertain a new trial. And that's what Justice Gantz reasoned, and I think that's correct in the sense that Justice Gantz reasoned, look, the defendants moved for a new trial, so I don't have to worry about double jeopardy principles, and thus I can use the second sentence as a tool to enter in a verdict more consonant with justice, as the SJC would have done if they had reviewed
Well, he
the
moved for a new trial. That's what he wanted, a new trial. He didn't ask for anything in between.
You know, in Preston, we held that, this is 1984, so this is a long time ago.
It is, Your Honor.
That the Commonwealth claimed in that case that the defendant had filed a Rule 30B motion, and the Commonwealth claimed that the judge had erred in considering that motion under Rule 25B2, and we said, oh, you can do that. So it wasn't as if Judge Gantz was off on a frolic and detour. I mean, we said, you know, the defendant's motion for a new trial, although denominated as a Rule 30B motion, should have been made at the same time, could have been made at the same time under Rule 25B2.
Yeah, but that motion was timely. This one wasn't.
Well, and again, Your Honor, I don't think there's, for that second sentence, that I'm very confident that the case law is that, I mean, I think there's one case, the longest case was something like 2 years, I think someone moved under the second sentence of 25B2, if my recollection serves me correctly. And I couldn't find anything longer because I was looking, I was hoping to find something 10 years, but I couldn't find anything that far out. So, and the court has noted, I will state the court has noted in the cases that I cited in my brief that, geez, maybe we should amend that rule. Maybe that rule should be limited to a certain time period. But it hasn't. And again, Justice Gantz was searching for a place to put his hat, and he said, you know what, a reduction to second-degree murder serves the purposes of justice. And I know the defendant wanted a new trial, but at the same time, too, as long as he gets a just result, based on the evidence, based on the way the case was tried, I do believe that result is proper.
Thank you, Mr. Van.
Thank you, Your Honor. I appreciate your time.